Hi, I'm Blake Zaccagnino. I'm an attorney that works mostly on personal injury claims in New York, and I wanted to react to a video entitled House Party Causes Damage to Downstairs Neighbor. Okay, so it looks like it's in Montreal. Looks like there's a party that's going on upstairs, and that it looks like the ceiling is about to collapse and that there's debris falling from the ceiling down. So people must be bouncing around on the upper level. There's debris falling
Oh my
down.
God.
Oh, this is wild. This is wild. Good thing he's noticing this and it's not happening overnight. Okay, so that is crazy, and I'm happy that no one was injured. But what this made me think about is a legal concept called res ipsa loquitur. That's RESIPSA. And generally, what that means is that the happening of the accident itself, or how the accident actually happened, is evidence of negligence. And generally, you see this happen in cases where it's so clear that whatever happened was negligent that it allows the jury to infer that negligence was involved in the case. And I wanted to go through a basic definition of what it is based on some case law to give a further explanation. So I'm reading you something from a case from the Court of Appeals, which is the highest court in New York State. And I want to read a few different parts of this case. So it says, in a personal injury or property damage case, it is the plaintiff's burden to prove the defendant was negligent. So yes, it's the plaintiff's burden to prove negligence in those types of cases. Occasionally, however, a plaintiff to whom the defendant owes a duty of care is not in a position to prove directly what actually happened or that a specific act of the defendant was negligence. In a proper case, under the doctrine of res ipsa loquitur, the law allows a jury to consider the circumstantial evidence and infer that the defendant was negligent in some unspecified way. So this would be, for example, in a ceiling collapse case, in a case where a product explodes, cases where it's evident that something negligent took place that led to the accident happening. Another portion of the case is res ipsa loquitur does not create a presumption of negligence against a defendant. Rather, the circumstantial evidence allows but does not require the jury to infer that the defendant was negligent. And there's three separate elements that would allow a court to either instruct a jury on applying this standard or applying it in the form of a motion, which is more rare. But the criteria for res ipsa loquitur are: 1, the event must be of a kind which ordinarily does not occur in the absence of someone's negligence. So yes, that's what we've been talking about. It must be caused by an agency or instrumentality within the exclusive control of the defendant. So it has to be something that was exclusively in their possession and in their control. So if there was some third party that had any influence on it or control over it, ordinarily and generally, this doctrine would not apply. And third, it must not have been due to any voluntary action or contribution on the part of the plaintiff. So in the falling ceiling incident, for example, a guest to the home is simply standing underneath it and it falls. So clearly that guest had nothing to do with the maintenance of the property or the ceiling. They were just there as a visitor and the ceiling falls on their head. So just a quick explanation of the doctrine, and it just goes to show you that in these New York injury cases, sometimes the law is clear-cut and it's simple, but a lot of the times the law is detailed and specific and complicated. Thanks.